Good afternoon or morning, everyone, and thank you for joining us today for our webinar on 5 things you should know before selling your business with our host, Wayne Zell. I am Kat Parker, Marketing Director at Zell Law, and I will be your co-host today. There will be a few polls throughout the presentation, and all of your answers will be anonymous, so feel free to answer honestly. We will also have a Q&A and a brief survey at the end of the presentation. Please chat me if you would like to receive CE credit for this hour. And now I'd like to turn it over to Wayne Zell, the founder of Zell Law, an estate and business planning law firm with offices in Reston, Virginia and Savannah, Georgia, serving clients nationwide.
Thanks, Kat. It's great to be with you today, and thanks for joining us. And hopefully you're going to learn something new that you don't know from before, or it'll reinforce some things that you know about how to get your business ready to be sold. 5 things that you should know before selling your business. And let's jump into it. And by the way, if you have questions, put them in the chat, and Kat will interrupt me as we go along. And we're going to have some polls throughout this process today too, so that you can have a little fun, answer some questions about things that you know or why you're attending the seminar. So let's get into step number 1.
And Wayne, before we start that, I do have a poll.
You have a poll question. Go for it.
I do. All right. Poll number 1. I am interested in this topic because I need the continuing education credit. I am interested in selling my business. I'm interested in learning how to help a client sell their business. I like listening to the speaker's resonant voice. Or I recently sold a business and want to learn what I did wrong.
So everybody vote for your single favorite answer. And we'll post the results in a second. I don't know if everybody's on yet, so but hopefully we've got a good quorum to start.
Okay, so it looks like I got most of the answers.
All right.
And I have shared the results.
86% want to help clients. 1 out of the 7 folks who are on today so far, and I know that others are going to be joining, but is interested in selling a business, and nobody wants to hear my voice. Well, too bad. We're going to keep going. All right, so you can close that. All right, so the 5 things that we're going to focus on today are: what is the process? How do you go about doing all the things you need to do to get your business ready to be sold? So it is a process, and it's important to understand the various steps in the process. And actually, I've focused on 5 steps, so we're dealing with the number 5 today a lot. The second piece that we're going to talk about is your business house in order. And there's a whole separate section in this presentation where we're going to talk about what it takes to get your business house in order. The third thing we're going to focus on is really, what is the business worth? How do we make that determination? What are the do's and don'ts prior to selling the business? What are the things that we need to do to enhance the value of the business before trying to offer it for sale? In other words, what are the value gaps and other things that we're going to focus on? The fourth area that we're going to focus on is, how do we keep this confidential so that our customers don't learn about it before it's time for them to learn about it, so that our employees don't learn about it before it's time for them to learn about it, so that we risk the loss of any of those important components in our business. And then lastly, we're going to talk about negotiating the deal, not just the price, because price is part of the deal, but it's not the whole deal. So what is the process? I think there's a poll question coming up.
Yes, we do have one.
All right, so before I dig into this, who should be on the team? Go ahead, Kat.
Who should be on the team to sell the business? Select as many as you feel appropriate. Key customers, key employees, all employees, general counsel, M&A lawyer, investment banker / business broker, and CPA. All right, about half.
And there are other choices too. You can always have other people on the team, but we'll talk about the team that we typically see assembled.
Almost got everyone in here. All right.
And the results are key employees, 57%. Interesting. All employees, 0. General counsel, 5 out of 7. M&A lawyer, 6 out of 7. Somebody feels that we don't need an M&A lawyer involved in the transaction. And then number below that, everybody agrees that a business broker or an investment banker should be involved, and most everybody agrees that a CPA should be involved. Well, I have my own views. Let's close that out, and let's focus on who I think should be on your team when you're getting ready to sell your business. Okay. I think you need attorneys involved because attorneys ultimately end up drafting the definitive agreements that are involved in these deals and often are involved deeply in the negotiations of those agreements. I think it is a good idea to talk about having CPAs involved, to have the management team involved, or at least key employees, maybe some support staff, and I'll explain why, and then an investment banker or a business broker is essential in most deals, but not all deals. And I'll give you an example of where we didn't use one in a fairly large deal and we had a very successful result. So the attorneys, it's always good to find somebody who knows how to sell a business. A divorce lawyer, a general practitioner who does litigation, somebody who does real estate law, they may not necessarily be the right person with experience in selling a business, maybe in selling a piece of real estate, but not in selling a business. So finding a lawyer who's been involved in sell-side transactions, I think, is a critical component. But also it's got to be somebody who has knowledge of your business, which then indicates that maybe we want to get the general counsel, the regular lawyer on the outside who's been involved. So if you're a government contractor, and you've got a government contracts lawyer involved in your business on an ongoing basis, you definitely want that person involved in the sale of your business because they're going to understand the contracts that you've been involved with, the bids and protests that you've been making, and the subject of any bid protests that you've been involved with. I think a government contracts lawyer should be involved if you do government contracting. If you don't, somebody who specializes in your business. You should check out their reputation. It's not just looking on Avo or on Google, reviews. You should be calling former clients that they helped sell their business and get referrals from them to see if they did, in fact, do the right thing for them and a good job for them. The types of lawyers really depend on what you need when you're selling your business, but clearly a corporate lawyer, somebody who understands how to sell a business, how to set up a business, how to dissolve it, how to sell shares of a business or units of an LLC. A tax lawyer is usually critical in this whole process. An ERISA lawyer, somebody who knows employee benefits and welfare benefits, is really critical. Somebody who knows the industry as well. So if it's retail or if it's hospitality or government contracting or technology, it's good to have a lawyer involved who understands the nuances of the industry. Employment lawyers, environmental lawyers, somebody who knows finance and accounting, and securities lawyers, depending on the size of the business and who we're selling to and how we're selling. You also have to make sure that they have the bandwidth to represent you. In other words, do they have too many deals on their plate? Do they have the right fee structure for you? Some lawyers will work with you and charge you a reduced fee until the actual sale transaction occurs, and then they get the discount back plus a premium. Others will just bill you on their hourly rates. A few lawyers will bill fixed fees on sell-side transactions, but that's dangerous for both parties involved, because if you are just doing a fixed fee arrangement and you have a difficult lawyer on the buy side who wants to negotiate every last T and I that needs to be crossed and dotted, then the lawyer may not be as interested in making sure that you're protected on the sell side. So fixed fees can be a loaded gun in some cases, but always understand what the fee structure is and how it's going to work going forward. CPAs are also a critical component in the acquisition process. I've worked very closely with many CPAs over the years. I'm a CPA, but I've worked very closely with many CPAs, particularly on the tax issues because they can run the numbers. They have familiarity with your business if they're your regular CPA on all the tax issues that come up from day to day, annually, and in the past. So they're going to be familiar with what your tax situation is. And if they've done merger and acquisition work, M&A work before, they'll be really helpful in structuring the deal as well as making the deal come to fruition. Also, some CPAs have a lot of experience in doing due diligence, actually getting the house in order and making sure that things are presented to the buyer in a way that they can understand your business and also be up to date on all of the issues relating to your business, because you want to be transparent as much as possible when you're selling your business. Accounting issues, Q of E, quality of earnings analysis. That's often in the diligence process. We're going to talk about that in a few minutes. But somebody who has dealt with Q of E analysis, quality of earnings, is really important in the team that needs to manage the process of selling your business. The management team. Well, sometimes the whole management team may be included. Sometimes it might be the CEO, key shareholder, who is also the CEO or president, and it might involve the CFO, the chief financial officer or vice president of finance. In a big transaction, you're going to need a bigger team because you're going to need support people to assemble all of the contracts that you've ever entered into that are still active, all of the non-disclosure agreements that you've signed, all of the leases that you've got for equipment and real estate and so on. They have to be involved to be able to put that information into some form of a data room or data format so the buyer and its representatives can do their due diligence on the seller. So usually having a support person who's under a strict confidentiality agreement is important, but there's always this risk that there might be a breach of confidentiality. And we'll talk about that a little later as one of the 4 agenda items. You still, if you're going to bring in management people into the business and you're going to bring in support people, you still got to keep your eyes on the business, keep it running, keep it moving forward, keep it growing, because that's where the value is. And you're going to get the highest value in that transaction if you keep growing the business in the direction that it had been growing and not take your eye off the ball. Last on my team that I would assemble is an investment banker or a business broker. Now, business brokers are very different from investment bankers. They're usually very knowledgeable about your industry. They have probably a good Rolodex, a good contact list of people that might be interested in your industry. And they're usually, as potential buyers, and they're usually very helpful in terms of helping to structure the initial deal. But their fees are often lower because the size of the deals that business brokers work on are significantly lower than what an investment banker might be involved with. So for example, if the purchase price of the entire deal is less than $20 million, you're most likely going to see business brokers involved. If it's over that threshold, you'll see investment bankers tend to get involved in the transaction. The investment banker charges usually a higher fee. Depending on the industry, depending on the transaction, it's usually a percentage of the purchase price. And most of the times, both the business broker and the investment banker get a non-refundable fee to help you put together your story as you're taking it out to the marketplace. But in either case, they're really important, and I would strongly recommend that you consider hiring an investment banker or a business broker if you don't have a buyer in hand. Have your attorney, who's experienced with M&A transactions, review the engagement agreement with the investment banker or business broker first before you sign it, because you may not be signing something that is fair to you, and it may be overly fair, if you will, to the investment banker or business broker. And again, focus on fees, but focus on reputation and what they're going to do for you. Some investment bankers will be involved from the very start of the transaction all the way to the very end. And what I mean by that is they may help you significantly, not only in pulling together all the data that you need to give to the buyer so that they can evaluate your business, but they may help you pull together the disclosure schedules that are absolutely critical in doing a merger or acquisition or sale transaction. And you may not have the bandwidth in-house to handle that. Having the investment banker help you with that is a really valuable scope of work and a valuable piece of the engagement. So we've assembled our team. We need to get our business house in order. And again, I'll talk about that in real detail towards the end. But the three things that you need to focus on are your legal diligence and cleanup, and doing an audit, not a financial audit, but a legal audit of your situation. All the governance documents, are they in place? Are they current, up to date, and signed? Do you have employment agreements with all your individual employees, or at least non-disclosure and non-interference agreements with them, where they've assigned you the right to any patents or trademarks or trade secrets that they're involved with in the business? Is there a non-compete agreement with the employees? Do we have a list of all of our customers, and do we know if our clients have any control over whether or not we can sell the business? Because in some contracts, there may be a consent that has to be given by the client as well as by other vendors. So legal cleanup is important. Finance and accounting, we'll focus on that in a few minutes, but that is absolutely a critical component of getting your business house in order. And if you have a good finance person on board initially to help you with that, great, because they're going to have a heavy burden, a heavy lift when it comes to selling the business. And then lastly, are your operations documented? Are your processes documented? The more you've done to document all your operations and all your processes and have them in order, so that when a buyer comes in, they can see how well run you are and how up to speed you are in your sales processes, marketing, infrastructure, IT, all of that stuff. If it's in order and ready to go, then it adds value in the end. That creates a value add to the sale price when you're getting ready to sell your business. So we're still talking about the process. It's one of 5 things we're talking about today. There's a lot to talk about in this 1-hour session. What is the right process for your deal? There's 3 basic processes that we deal with when we're trying to sell a company. The third one, the one that's marked O3, known potential buyers, well, you may have been talking to somebody for years. They may be a strategic partner of yours. They may have been using your services. They may have been relying heavily on your services or products, and they want to integrate you into their business. That's known as a strategic buyer, and you may already have that person lined up. If you do, we'll talk about what you should do. An auction process and a limited auction process is a little bit more geared toward an investment banker or a business broker. The auction process basically assumes that you're going to hire an investment banker or business broker to help you market your business. And what they're going to do is they're going to come in and study your business inside out. Look at your financials, look at your books and records, meet with management, look at your projections. And if you don't have projections, help you build them. And then they prepare an offering memorandum that they take out to the universe. The IB, the investment banker, does a deep dive and they take out an offering memorandum that they'll prepare, but you have to review, make sure it's accurate. And they take it out to the universe of prospective clients, which might include strategic buyers, private equity firms, and family offices. They send out the offering memorandum after a standard NDA is signed, non-disclosure agreement. Now, one thing about non-disclosure agreements, they're not all the same. And when it comes to an M&A process, you want a non-disclosure agreement that is ironclad and geared towards the person who's investigating you, not stealing your customers or your employees. We'll talk about that at the end of this session, but that's really important. Then the investment banker goes out, has a list of maybe 100, maybe more potential buyers for your business, and they get an indication of interest, a letter that basically says, here is what we're interested in paying for your business within a range, but it's before we've done any due diligence, and obviously that may change once we've started our due diligence. But here's a range, and here's why we would be a good fit for you as a buyer for your business. That's an indication of interest. Then the detailed letter of intent comes. And it's the best deal that's in the letter of intent that we're looking for. Not, again, not just the price. Then we might have the draft purchase agreement attached to the LOI, or ask for a buyer to give us a draft purchase agreement as part of the LOI process, so that we can see where they're coming from in terms of how much they're willing to negotiate with us on representations and warranties, on indemnification, on liability, on the things that the lawyers really need to negotiate. If we get a contract back from a prospective buyer that's really fair, then that's a great indication of interest that they want to buy us. And so the auction process is really well suited for the fast growing, high demand business. A lot of government contractors who are in cybersecurity, a lot of folks in the healthcare industry, technology industries are still high flyers, even with the volatility in the stock market today. A limited auction process really is taking the auction process but saying, I don't want to go out to 100 potential buyers. There's about 10 companies that I think would be interested in me, or 5 companies that might be interested in me, or even 2. And then maybe there's some private equity firms that want to invest in this type of business. So it's a smaller targeted group, but otherwise similar to an auction. And I mentioned known potential buyers. And what do I mean by that? Well, it's somebody that, let's go back. Let me go back for a second. I think I was clicking too fast on that. All right. So a known potential buyer is the devil you know. It's somebody you've been dealing with for a long time, or maybe even a short period of time, but you've gotten very comfortable with them. You might be rendering services to them. You might be buying services from them. You might be providing contracts or products to them. And it's somebody that sees the synergy between you and them. That doesn't mean that you don't need an investment banker. I've been told by many clients over the years who've been purchased by strategic buyers that having an investment banker involved still was helpful. Now, I was recently involved in a transaction where we sold a registered investment advisory firm out on the West Coast to a large family office out there. And we did not use an investment banker. In fact, the client, who I knew very well, said, we want you to do it, Wayne, because we know you have the skill set, and we don't need an investment banker because our team has the skill set to do the evaluation, number crunching, and all the other stuff that needs to be done. And we feel comfortable without an investment banker because we don't believe that an investment banker is going to be looking out for our specific interest in this deal. And so we didn't use one, and it was a very successful transaction. But I still lean towards always hiring an investment banker or a business broker. Then, once we've got the process down, we want to negotiate the deal.
And we do have a poll, Wayne. So
go for it.
All right. In my view, the most important part of negotiating a deal is, go ahead and pick you guys' top 2, preserving my company's legacy and values, how much money I can keep after taxes, taking care of my employees, taking care of my customers, and limited liabilities going forward.
There's no right answer here, by the way.
Make sure you pick your top 2. A few more seconds. All right. And the results.
Interesting. I love this. I love the way these answers pan out. And I'll give you a war story in a second. But the taking care of my employees came in at number 1 on this list. Keeping enough money after taxes is number 2. And tied for number 3 was preserving company's legacy and values and limiting liabilities going forward. So the top 2 answers were taking care of employees and keeping money after taxes. I do a radio show, a video cast called Blueprint for Wealth. And I recently interviewed one of my guests who I helped sell their business. And her comment to me was taking care of the customers and taking care of the employees were the two most important things to her in that particular transaction. And the reason I think was because they didn't really need to sell the company, but they were contemplating it because they needed to plan for business succession and make sure that the younger generation was going to be taken care of. So the combination was very culture oriented. And so it had to have a culture that was very similar, almost identical to the seller's culture. And that became the driver in the deal. And the price became less important, believe it or not, when we were negotiating the transaction. All right, so let's close that off. And so the part in step 4 of the 5 things you need to know is negotiating the deal. It's not just the price, it's negotiating the deal. And what does that mean? Know what you want before you sell. Well, let's look at that. Well, obviously knowing what the bottom line price is really important. But then make sure you've got tax counsel and CPA lined up to evaluate the tax structure of the deal before you sign off on it. And this would be at the letter of intent stage. So what is the money that you can put in your pocket after income taxes? For example, if you're an S corporation and you want to sell your stock, normally when you sell stock and that's all you're selling, you get capital gain on the sale of the stock. But the buyer of an S corporation wants to be able to write up the fair market value of all of the assets of the company and write them off for tax purposes. So they get a benefit if they do that. And there's a special election that they have to make. It's called a 338H10 election or a 336E election. And those elections allow the buyer to step up the basis of the assets and write them off over a period of time. Well, there's a cost to the seller of doing that. It might cause the seller to recognize some of the gain as ordinary income, taxable at much higher rates. So there's a negotiation that goes into the structure of the deal. It should be at the LOI stage. Don't wait until after. Do you need to keep working after the sale? In other words, have you done your financial planning enough to know how much money you really need to live on and how much money you can afford to live on after the transaction is over? Do you want to keep working after the sale? Because a lot of my clients just want to keep in the business. I have a client, years ago, we helped him sell his business to a very big company, and he walked away with millions of dollars. He could have retired, but he was only in his 40s. And he's continued to work for the company. I think it's 7 years after the transaction took place. And he's very happy working for the company because he loves to work. So it really depends on the seller in this case. Proceeds. What kind of proceeds do you want out of this deal? Well, most everybody wants cash and they want it up front. I want my cash and I want my cash now. At least I know what I'm getting. Well, if you get rollover equity, which means that some of the purchase price is paid in equity of the buyer, then you may or may not have to pay tax on that, depending on the structure of the deal. And is it really worth it to get rollover equity in an entity that is being funded by a private equity firm? Well, some people think it's really valuable. I'll give you an example. I've got a client, they're in the middle of a transaction right now to sell off the company. We sold them to a private equity firm last May. The current transaction is going to be 4 times what the sale was last May. And they're about ready to close on the transaction. And so those who took rollover equity in that deal got 4x of their rollover equity investment. So it was well worth it. Sometimes it is, sometimes it's not. And the last thing about earnouts. Earnouts are tricky. What is an earnout? An earnout says, well, I'll pay you, the buyer's going to pay you cash up front at closing, but they'll pay you some additional cash if you achieve certain milestones after closing. It might be keeping a certain level of customers. It might be generating a certain level of revenue. And it might be generating a certain level of profit, or a combination of those factors. Whatever the factors are, the less control the seller has over the earnout after the sale, the more concerned I get as their attorney in negotiating the earnout for them, because the buyer might be able to manipulate the facts to prevent the seller from getting what they should have been entitled to in the earnout. So the earnouts aren't great. They're hard to negotiate. And if you have to have one, try to do it in a way that it's fair to the seller as well as to the buyer. And what would happen if you didn't sell? You should run the numbers. Because if you sold the company and you got, $1.5 million or 10 million and a half for your business, but if you continued working for 3 or 4 years and you're able to do that, you'd get the same amount. Would it be worth it just to hold on to the business and sell it later, or just transition it to the management team? A word about taking care of employees. Some clients really focus on that heavily. Others are really weary and they want to sell their business and they just want to get out and get their money and move on. It really depends on the business. Like I mentioned earlier about the company that really valued its employees, you can take care of your employees either before the transaction, during the transaction, or after. How do you do that? Well, before the transaction, let's go back to that slide. Before the transaction, you can take care of them using a change in control bonus, meaning that if the company's sold, maybe you'll pay them a certain amount of money or a certain percentage of the net proceeds after all the expenses. You could give them stock options. You could give them restricted stock units, which is what an RSU is, or shares. There are ramifications to doing that before the sale. Securities law issues, tax law issues predominantly. And so you want to be careful about what you agree to and what you give them and how it's treated before you enter into that promise. Continued employment. You can give them a retention bonus. So if they stay with the company for a period of time after the company is sold, they might get a piece of the proceeds that otherwise would have gone to you as the seller. Or the buyer might be willing to fund a retention bonus pool as part of the deal. It's all part of the negotiations. But key employees will definitely want to talk about how guaranteed is my employment or is it not? Am I an at-will employee that they can terminate me the day after the closing? That's always a concern to the key employees who are involved. And then lastly, non-competes. When you're selling a business, the seller of the stock, the person who controls the business, always will have to enter into some form of non-competition agreement with the buyer. But then the question is, what about the key employees? The buyer wants the key employees also to enter into some type of arrangement to bind them from taking company customers, from taking company employees, from competing with the company after the sale. And that becomes a major part of the negotiation. They generally would be benefited by having their own separate counsel represent them. And then it's always good to get this information early in the process as opposed to at the tail end of the process, because it could delay the closing of the transaction if there are employment agreements to be negotiated and non-compete agreements to be negotiated with the ongoing, continuing employees. How do you structure the deal? Again, what's the bottom line price that you want out of this? What is the price and the cash after tax that you're going to get after the structure is built? Those are critical. And then the other critical components that people forget about in negotiating these deals is the buyer wants to ensure that there's a certain amount of working capital that's left in the company before the company is sold and after the company is sold. And if that working capital is your current assets minus your current liabilities. So it's cash and receivables minus your payables, basically. They want to make sure there's plenty of operating capital in the business so that they can continue operating the business without having to put more cash into the business in addition to what they're paying you to sell your business. So the target working capital negotiation could result in an adjustment to the purchase price. If there's more than the targeted working capital, then the buyer usually has to leave that excess working capital with the seller. And the seller gets to treat that as an additional component of the purchase price and keep it. If there's a deficiency in the working capital, the seller usually has to make up for that deficiency. Oftentimes, there's an escrow that's set aside that might be a band around the targeted working capital to protect the buyer from any deficiency. And if there's no deficiency, again, after a period of time to determine what the working capital actually was at closing, then the excess can either be paid out to the seller or kept by the buyer. You've got to know what the proceeds are in the transaction. If you're getting cash, that's easy. But if you're getting promissory notes or you're getting rollover equity or there's an earnout, that really complicates the structure of the transaction. And we want to be extremely careful about how we structure this because it's all going to play into the tax treatment of the deal as well as what you get after all is said and done. And again, the last thing, what would happen if you didn't sell? You always should ask that question when you're selling your business. Is there a question?
Nope, no questions so far.
Because I see a Q&A. And the anonymous attendee says, will we get a copy of this recording? We will post it to our website. So I don't know if, Kat, you're even able to see this, but we'll post it to our website so that people can download it. Last, papering the deal. Letter of intent, LOI, and due diligence. That takes longer than most people realize. The key components of the transaction should be included in the LOI. And that's, again, that's not just the price, it's the structure of the deal. Ideally, it's who the key employees are and what their comp will be. Ideally, it's what the terms of any non-compete agreement are going to look like. We like to put as much into the letter of intent phase as possible before we get into the 60, 70, 80 page purchase agreement that buyers like to present to the sellers. In some deals, the purchase agreement might be 5 or 6 pages. That's in a friendly acquisition where the person who's doing the acquiring knows the business so well because they may be working for it or something like that. But usually it's a much more complicated transaction. And the LOI is really important. And the LOI authorizes deep dives into the data that the seller has, everything that the seller has, all the contracts, what the employee census looks like, what the compensation and benefits look like, what the filings have been with the IRS and the Department of Labor, what securities law issues there are, what litigation is there. All of that stuff has to come out before you can really do an effective purchase agreement. And then the purchase agreement is negotiated. And as part of the purchase agreement, there are disclosure schedules that get attached to it. The disclosure schedules usually reflect exceptions or items that are referenced in the purchase agreement. I'll give you an example. Section 3.10 of the purchase agreement says, listed on Schedule 3.10 are all of the material contracts of the seller. What's material? What's a contract? Is it an active contract? These are all things that have to be discussed, but the disclosure schedule would list all of these contracts. And believe it or not, in a well-done acquisition, you want to do that because transparency is absolutely key in an M&A transaction. That way the buyer can't come back and say, you omitted giving us a material fact in the transaction. You defrauded us and we're going to sue you for fraud, which could unwind the whole transaction or cause you to return all the proceeds. We don't want that for any potential seller. Let's disclose everything that we need to disclose in the transaction. And the ancillary agreements are also critical. What are the ancillary agreements? They may be a promissory note. They may include employment agreements, the non-compete agreement. It might include special side letters with certain individuals. ancillary agreements usually are absolutely critical to doing the deal. So that's part 4, step 4 of the 5-part process in negotiating a sale of a business. Lastly, the 5th step is focusing on the finer points. And I mentioned diligence. Diligence usually boils down to these 6 categories. But I have seen a diligence questionnaire that was 26 pages long and had over 150 items on it in a recent transaction that we did. And it was detailed, and we had to respond to every question, whether it applied or it didn't. If it didn't apply, we would say NA, but we'd have to make sure that it truly was not applicable. I mentioned quality of earnings analysis. What is that? When the buyer wants to ascertain the value of what it is that you have reported to them in terms of financial information, not just financial statements, but all the books and records, your general ledger, your trial balances, your pipeline, your the backlog of contracts that you've got. The buyer hires an independent accounting firm, it could be their accounting firm, to go in and do absolutely detailed diligence on your financial situation. And they'll come out with a report that they hand to the buyer at the end of the analysis. And usually when there is a need for reps and warranties insurance in a transaction, you'll see that at the bottom, R&W, reps and warranties insurance, they require quality of earnings analysis. And in more and more deals, it's being done. It used to be where it was a minority of deals where you'd see quality of earnings analysis. I talked to an investment banker client of mine the other day, and his comment was over 50% of all government contract deals that they're working on are requiring quality of earnings analysis. Technology diligence, they may bring in a specialist in software or the technology that you may have developed in your company. They will evaluate the efficacy of the technology as well as the ability to acquire ownership of that technology as part of the transaction. Same thing with real estate. If you've got real estate, there are going to invariably be requests for an environmental phase 1 study of the property and possibly a phase 2 study, which means that they've got to make sure that there's no liabilities lurking on the real estate that you own or that you lease, because even if you lease the property, there could be ongoing environmental liabilities. And then legal diligence. The lawyers really need to be involved, in my opinion, at the data room formation stage with the investment bankers. The investment bankers like to keep them at bay because they don't want the lawyers charging their fees for this stuff. But the problem is it's the lawyers that have to determine whether or not we have to go out and get consents from our customers, from our landlords, from our vendors to allow this transaction to move forward, which is usually one of the things that comes up at the last minute, and it tends to delay deals. We need to be able to look at the contracts to see if there are any non-competes or any other types of provisions that will inhibit the ability of the buyer to buy the business. The buyer is going to do the same thing. They're going to bring in their lawyers, but we can't rely on the buyer's lawyers to tell us what our risks are in the deal if we're representing the seller. And of course, trade secrets and intellectual property protections. Are they there? Do we have it? Can we transfer this intellectual property that we claim that we own to the buyer? Tax and ERISA, absolutely critical in the due diligence process. We always bring in an ERISA specialist when there are employee benefit plans. And lastly, third-party diligence. Well, if you have a bank that is providing financing to the buyer to acquire your business, the bank usually will bring in their diligence team to analyze the ability of the seller to generate cash flow to pay back the bank loan on behalf of the buyer and to make it a good deal for the bank, because the banks don't want defaults and they don't want people defaulting on the loans that they're making to acquire these businesses. And then lastly, R&W insurance. Reps and warranties insurance is another thing that's becoming more popular, usually in deals that are over $50 million. I've seen them. But what it does is it allows the buyer's counsel and the seller's counsel to relax somewhat and not get involved in negotiating every T and every I in every provision of the representations and warranties in the contract that the seller typically has to make to the buyer, and sometimes the buyer making to the seller. So the reps and warranties insurance underwriter will come in and do due diligence on the transaction as well. So there's a lot of details in the diligence side of a transaction. Other fine points of the deal, the letter of intent I mentioned is something where you want to have more detail than not, but it's usually structured as a non-binding letter of intent with the exception of certain provisions in the contract. Certain provisions will be binding, like it's confidential, that the buyer has the exclusive right to negotiate with the seller for some period of time, usually 45 to 90 days. And if the deal's not closed in that time, the seller can start talking to other people again, as long as they haven't violated the terms of the agreement. Other binding provisions usually talk about governing law, and if there's a dispute, does it go to arbitration or will it go to litigation? The rest of it is non-binding, including the purchase price, but it's usually a meeting of the minds of what the price and the structure is at the front end that drives the purchase agreement. Lastly, the purchase agreement has 4 main components. One of the most important components for the lawyers is the reps and warranties, knowledge qualifiers, and materiality qualifiers, meaning that to the best knowledge of the seller, I am not aware of any litigation, or there's no litigation, or something like that. Materiality, there are no material breaches of any contract. These are heavily negotiated in the absence of reps and warranties insurance. The escrow is the buyer demanding that some money be set aside to protect the buyer if there is a breach of a rep and warranty, or if the targeted working capital hasn't been met. The escrow agreement becomes an important component. And of course, the price and the earnout and price adjustments usually take up a good 10 to 15 pages potentially of the initial part of the agreement. And lastly, covenants, promises that the buyer is making to the seller post-closing, meaning that can the seller compete with the buyer after the deal is done? Usually the answer is no, and usually it's for a significant period of time. Then the question is, what does the non-compete say and what does it not say? And who should it apply to? That's where the negotiations get very sticky. So 5 steps in the process of doing an M&A transaction. How do you get your business house in order? We saw this slide earlier. The legal and cleanup piece is really important, but these are some of the issues that you have to deal with when you're dealing with the legal issues in conducting due diligence and getting your company ready for sale. Are there OSHA issues? Are there product liability issues? Have you made any warranties to your clients that are being transferred as part of this deal? Is there any outstanding litigation? Has there been any litigation? What's the outcome of it? Do you have your corporate governance documents in order, like your minutes and your consents and all the approvals? Have contracts been reviewed for any consents that may be required to close the transaction? Are we in compliance with the Department of Labor and the IRS under ERISA and benefits? And do we have any tax compliance issues, audit history? So the best thing to do is to assemble a data room ahead of time before you even entertain buyers and get a standard diligence room set up so that we've addressed all these issues. And lastly, one of the big issues for employees that I've run into in many deals is, do we have an I-9, which is the immigration form you have to get at the very front end of anyone's employment with the company? Do we have an I-9 for every employee? Do we have non-disclosure agreements with the employees or non-competes? The buyer wants to know, and they're going to want to see every single one, even if you have 500 employees. On the finance and accounting side, you're going to need at least 5 years of financial statements if you've been in business that long, and you're going to need the backup to it so that the buyer and their quality of earnings analyst can go in and look at this documentation. You may want to consider doing an outside independent audit in the year prior to the sale, and then have the books and records in really top shape when it's time to sell. You want to make sure you have projections and forecasts, because that drives the upward value of the business. Even if they're unrealistic to the buyer, it gives you an argument to justify a higher purchase price. And then, of course, a detailed backlog of your pipeline and your backlog of contracts to make sure that they know that there's something supporting your projections and your forecasts. And lastly, on the operations and process side, often overlooked, often a value gap in valuing a business, where we don't have our operations really well documented and our processes really well documented, such as our sales process or our business development process, how we generate leads, how we close on them, how we satisfy customers on an ongoing basis. And having documentation for each department, including your IT department. And one of the big issues in M&A today is data privacy and cybersecurity. You'll see a lot of reps and warranties in the mergers and acquisition agreements that we see and we help draft to make sure that there have been no hacks, no compromises of your security as the seller. Do you own all your technology? Do you have valid licenses to them? Are you using open source software in your technology so as to diminish potentially the overall value? Because open source is owned by everyone, not just you as the seller. But if you've enhanced the open source with add-ons that are proprietary, you want to be able to identify those components and be able to segregate them from the rest of the business. So that's getting your house in order. I know there's one more poll question that we wanted to ask on this.
Yes, we do have another poll. The most important value driver in any business is, go ahead and pick your top two: intellectual property, including trade secrets, copyrights, patents, and trademarks; management team; employees; recurring revenue from existing customers; ability to generate new customers; pipeline of possible customers; or processes and policies.
Go ahead and answer that. Give us your top two, and then we'll cover these. What is a value driver, by the way?
All right. And there's the results.
It's a tie. Recurring revenue from existing customers and intellectual property, including trade secrets, patents, copyrights, and trademarks. Behind that, ability to generate customers and management team. So this is interesting. I don't agree or disagree with your comments. It depends on the company, right? Depends on if you actually have intellectual property. Because if you do, it does tend to be a large value driver. Your management team actually is an important value driver for private equity firms that are buying, and they're the vast majority of the buyers in the market today. And the ability to generate new customers, your pipeline, your processes and policies, believe it or not, are all really important value drivers. Let's go ahead and close that. What is a value driver? Well, there are different ways of measuring things that drive the value of the business. And for a government contractor in cybersecurity, it's very different from a government contractor who provides butts and seats, to their customers. And so, really, the value drivers. There's one valuation firm that's come up with 18 value drivers, and they'll come in and analyze your business and say, okay, here are the value gaps, the areas that you should be focusing on that you're not, and if you did focus on it more, there would be more value in your business. Like a management team, like strong processes and operations that are documented, like verifying ownership of your intellectual property. How do you fill it in before you sell? So doing the value analysis well ahead of the time when you're getting ready to sell, and then filling in the gaps is important. Who else can help you with value gaps? A board of advisors can help you with it. Your board of directors, if you have outside directors. People who are experienced in selling companies, who know what it takes to sell a company in your industry at your size. It's always good to have advisors, mentors involved. How would a strategic buyer see your business? And are there value drivers that your financial information doesn't reflect? Classic example, we put $1 million into R&D, research and development, on a new software product, and this software product is going to generate millions of revenue in the future, and we've already got a test case with a major Fortune 100 company. That's a value driver that will not be shown in your historical financial statements, because usually you write off or you capitalize the costs, and the cost is not indicative of what the fair market value is or will be in the future. And that becomes a big negotiation in a lot of these deals. And lastly, having projections. A valuation person is going to want to see projections. A corporate development person and a strategic buyer is going to want to see projections. And your private equity buyer is going to want to see projections. And if you don't have them, then you're selling yourself short. There are other valuation considerations that we should always look at, but we're running short of time today, and I want to leave time for a couple of questions. So before we hit that, confidentiality is a really hard thing to maintain in the sale process. How do you keep it quiet? Well, one is to think about having a special non-disclosure agreement for prospective buyers who are coming in through the auction process or otherwise into the company. And in that NDA, which I talked about at the beginning, you want to have a non-solicitation of your employees and your customers if you can get it in there. If they're willing to do that, that is really a valuable add-on to a typical non-disclosure agreement, and then having strong penalties and remedies that are agreed to ahead of time. Because why would you open your kimono and show them everything about you if you didn't have this protection in the first place? And then keeping it quiet at the company, what we often will do is enter into a special non-disclosure agreement with support personnel and key management employees to reinforce the need for confidentiality, but also there may be a carrot at the end of the stick. And that carrot may be a bonus. If you can help us successfully close this transaction, we'll pay you $100,000. Something like that. Outside the company, it's much harder. But the goal is trying not to let the prospective buyer or buyers contact your customers until it's absolutely necessary. And the same thing goes for your employees. And lastly, negotiate the deal, not just the price. And we've talked about this. There are other aspects in negotiating a transaction that are totally related to getting the best deal possible, but not necessarily related to the price. Like keeping your key employees on after the deal. It may be related to the price, it may not be. If you got all cash for the deal, then there's no price adjustment, right? So, but what about making the employees happy? So if you've built a culture where you really are rewarding your employees for great service and loyalty, we want to protect them. And they may say, like Tom Cruise did, show me the money. So, Kat, are there any questions that we've got? Or is there a last Q&A that we have?
There is one last poll question. If you guys would like to answer that for us. The best part of the presentation today was, go ahead and pick as many as you like. The speaker, the slides themselves, the content, I didn't have to work for an hour, or nothing, I did not enjoy the presentation.
Well, I hope I don't get one on that last one. But that's honest. We want transparency. And if you all want to stay on for another 5 minutes after this, we have a couple of questions from the audience that Kat can read, and I can help try to answer.
All right, and here are the results.
Well, that's good. Some people didn't enjoy it, but that's okay. They didn't say it, so they saved me the angst. of having to deal with that. But thank you. We appreciate it. If you all want to sign off, you can. Kat, I saw there were several questions, but I think we can handle two. Why don't you pick a couple and read them off, and let's see what we can see if I can answer these questions for you.
Sure. Can you talk a little more about the tax structures that may be used in a sale transaction?
Yeah, I think with an S corp or a corporation, it varies. Always think about what the buyer wants and what the seller wants. And so what the buyer wants is to write off the fair market value of the assets that they're buying. So if they buy assets, it's easy. But usually these transactions are structured as stock sales or LLC interest sales. And so the seller wants long-term capital gain treatment because they're taxed at a 20% rate on the long-term capital gain maximum. And the buyer is not able to write off anything if they buy just stock. So there's usually a negotiation that goes into making one of these elections that the buyer wants to make to treat it as an asset sale, but the seller is going to want to be made whole for the tax consequences of that sale. And so if there's additional ordinary income tax that's triggered because of what the buyer wants, maybe we can negotiate that into the letter of intent. That's as much as I'll say about that because it gets really, really, really complicated. And, so that would be my answer to that question, making something very complicated as simple as I can.
All right. What do investment bankers charge, and how does that compare with business brokers?
Always think of a business broker as dealing with a transaction that's much smaller. So, and again, under 20 million, under 10 million, they will charge as much, I've seen as much as 10% of the net proceeds of the transaction, which I think is high. The investment bankers, because of the size of the transaction, usually use what's called a layman formula or a modified layman formula, which is not a good, I guess, adjective to use these days since layman went out of business. But the formula is like a 5-4-3-2-1 or a 3-2-1, where it's a percentage of the proceeds that they charge, and it's the net proceeds. And as the proceeds grow, they usually get less. Sometimes you'll negotiate the opposite. If the proceeds exceed a certain level, they may get more, but it's all a negotiated transaction. But investment bankers always want to have a floor on what they make if the transaction closes. So if it closes under a certain level that you had hoped to sell it for, and you're willing to close it, the investment banker may still get its $600,000 fee, $1 million fee. They get paid very well in these transactions. So that's in a nutshell what I would say. I think that's it for today. We've run out of time. I'm sorry we ran out of time. But if you have any questions, you know how to reach us at Zell Law. Go onto our website, zelllaw.com. This recording will be posted up there for your use and enjoyment, for you to share with others. If you would like to do that, we would appreciate that. If you've got people that you want to refer to us that need help in selling their business, please think about us. If you need help, think about us. And then lastly, we'll also have our podcasts available and our videocasts on Apple, in the Apple Store. If you type in Blueprint for Wealth, you can visit us there and get some information on topics of interest that you may be wanting to listen to, or special guests that we've been interviewing every other week since August. And we've got guests booked and scheduled and interviewed all the way through July now, don't we, Kat?
Yes, we do.
So it's very exciting. Thank you so much for participating in this Lunch and Learn. I hope you got something out of it. And we'll see you next time for our next topic on Lunch and Learn. Thanks. Have a great day.